All rise. Veuillez vous lever. The International Criminal Court is now in session. L'audience du Cour pénal international est ouverte. Please be seated. Veuillez vous asseoir.
Yes, good morning to all. Yes, I think you better call the case again, please.
Good morning, Madam President, Your Honors. This is the situation in Darfur, Sudan, in the case of the prosecutor versus Ali Muhammad Ali Abd-Al-Rahman. Case reference ICC 02050120. And for the record, we're in open session.
Yes, thank you very much. Appearances, please, from the defense.
Good morning, Madam President, Your Honours, dear colleague. The defense team is the same as yesterday, with the notable addition of Madam Anin Khali.
Thank you very much, Mr. Laji. Prosecution.
Good morning, Madam President. Good morning, Your Honors. Good morning to everybody in the room. Same as yesterday. Thank you.
Thank you, Mr. Nichols. And finally, the representatives of the victims.
Yes, good morning, Madam President, Your Honors. Good morning to everyone in and around the courtroom. The composition is the same, with a valuable addition of a new case manager we have in our team sitting here in the middle. His name is Mohammed Bitar. Thank you.
Thank you very much, Mr. von Wistinghausen. Yes, Mr. Laji, I gather that the witness is ready, but it's a 6831, so you need to do a summary.
Precisely, Madam President. Witness D16 has given a statement to the defense setting out his opinion on the relevant provisions of Sudanese law contained in documents and statutes, including the 1998 Constitution, the 1991 Criminal Act, and the 1986 Armed Forces Act, on crimes that he finds equivalent to the counts for which Mr. Abd-Al-Rahman has been convicted, as well as the sentences applicable to those crimes in Sudanese law. Witness D16 also clarifies that some sentences, such as the death penalty and imprisonment, cannot be imposed on convicted persons who reach the age of 17 years, except in the exceptional case of the offense of iraba. I thank you.
Yes, thank you very much, Mr. Laji. Very succinct, if I may say so. Yes, can we have the witness brought to the room, please, where he is?
And I would like, with your permission, to start in closed session.
Yes, although, is that so that he can give some details of who he is?
I will ask him to identify himself, you know, the usual procedure.
Well, I was going to say, I mean, he's actually appeared before, but...
So if you don't need that...
well, I suppose... Well, no, the public won't hear about it anyhow, because they're not in court. I mean, because it will be in private session.
Yes, and he is a witness under protection program.
Yes, right. So I don't think you need trouble with that, but he'll have to take the declaration again. Sir, good morning to you, and welcome back to the court. Can you hear and understand me?
The witness, good morning. I hear you loud and clear.
As you know, because you've appeared before, your evidence will begin with the making of the solemn declaration. I don't know whether you've got a copy in front of you. Yes, you have. So I'm told. So would you be good enough to read it out, please? Thank you.
The witness, I solemnly undertake to tell the truth, the whole truth, and nothing but the truth.
Thank you very much, sir. I don't imagine you'll be here as long as you were last time or anything like that. I know Mr. Louch has explained to you what you're going to be talking about. So without further ado, Mr. Louch.
Thank you, Madam President, and I'm sure we have to blame it on my French accent, but in the summary that I read, the transcript got 17 years. It was 70. Just a correction. Good morning, Mr. Witness.
The witness, good morning, Mr. Louch.
Because that's the second time you appear in this case, Madam President has accepted that there was no need to go through the usual identification session, so I skipped that part. Can we have on the screen, not for the public, please, document in tab number 2 in the list, which is the second witness statement of witness D16.
Could counsel please read the ERN into the
Yes,
case record?
DAR D31, 5 times 0, 363. And I would like to go on page 2. Page 3, I'm told. No, page 2. And the page would have to be shown to the witness on the screen. Mr. Witness, I have asked the court to show you the second page of your statement. That's for you to confirm that the signature that appears there is yours.
Can I just
Answer, yes, it is my signature.
Can I just confirm, Mr. Louch, I've got the right statement. It's the one that runs to 27 pages.
That's the one dated 16 to 18 October. But yes, yeah, the other one was much longer.
Yes, yeah, thank you.
Do you see the document on your screen, Mr. Witness?
Answer, I do. I heard answer, I do. Can you hear me? Can you hear me?
Yes, we can hear you.
Mr. Louch doesn't, apparently.
I do not get the interpretation.
Yep,
Because yes, of course, my fault. Okay, so, sorry, I did not get your answer. Do you confirm that it is your signature? Okay.
Answer, I do.
Can we move to the page 26 of the statement, please? When you have it, can you confirm that it is as well your signature?
Answer, yes, it is my signature.
Thank you very much for that. Last week, on Thursday, 13 November, we had a preparation session. Do you confirm that before that preparation session, you had the opportunity to read again your statement that was given to you by the court?
Answer, yes.
And after
I was able to look at my statement.
Thank you. And after this reading session, were there any corrections, clarifications, or additions that you wanted to make to your statement?
No, no clarifications or additions to make, but I remembered that with regards to treating sheikhs, according to Sudanese law, there is a recent judicial implementation that was used with former President al-Bashir and Bakr Hassan Saleh, former Vice President, in addition to Abd-Al-Rahman Mohammed Hussein. The crimes they committed were not considered part of the hudud, or prescribed penalties crimes, or qisas, or retributive punishment crimes. Therefore, house arrest was applied on them, and they were treated like sheikhs, or elderly people. And there are published precedents in this regard issued by the Supreme Court of Sudan.
I thank you for this clarification. We had inserted a note about it in the preparation log, but indeed, what you just said is very valuable as a confirmation of this clarification. With that clarification, do you agree that your statement corresponds to the truth, to the best of your knowledge and recollection?
Answer, my statement is fully compatible with judicial precedents in Sudan and law in Sudan.
Thank you, Mr. Witness. And so, do you agree that we submit your statement into evidence before this court?
Answer, yes.
Thank you. So the defense will ask the second statement, DAR D31 5x0 363, to be admitted in evidence.
We agree.
Thank you.
Madam President. Well, no, I mean, we've made our position on that we oppose the submission of this statement. Your Honours have ruled on that issue. That's not why I'm rising
Right.
now. Just a small clarification to the transcript, which I think may be helpful, and I think it's some terminology that'll come up during the examination. So I believe the witness referred to hudhud crimes and also Qisa, Qisa crimes.
Sorry, where's that?
At lines, page 6, lines 25, and page 7, line 1. So just so that's clear. So
wait a moment. I'm sorry.
it actually says the rhymes, but the crimes they committed were not considered, and I think it should be hudud crimes or Qisa crimes. So and I think that terminology is going to come up, so just if that is helpful.
Yeah. All right. Thank you very much.
Madam President, with all the best attempt to stay in public, I have one question to ask in closed session that's related to the issue about the witness appearance today. that was solved before his appearance.
Well, if this is because you're concerned that the chamber might take a dim view of what happened, I think I can speak for all of us and say we're prepared to accept that there was some kind of misunderstanding.
Maybe the parties would like to get some explanation on this.
All right. Well, all right. If you want to do
Yeah.
it, Mr. Archer, I'm not going to stop
We
you.
don't need an explanation.
Well, okay, Mr. Archer, if you prefer to get an
Yeah.
explanation, we'll go into private
Thank you.
session.
We're back in open session, Madam President.
Mr. Witness, we are back in open session, and I have to ask you about a document that was shown to you last Thursday during your preparation session. That's document in tab 15 in the list of materials, DAR D31 5x0 366. It's in English. If we can have it on the screen, please. Available for the public. Tell me when you see the document, Mr. Witness. Yes, and this document also exists in Arabic. That's D31 5x0 367, tab number 16. But let's use the English version.
Apologies. 366 is currently being displayed, and it's the Arabic version. So if you wish for us to...
367 then.
Perfect.
My mistake. Mr. Witness, do you see the document?
Yeah.
Okay, and can you tell the court if...
The witness, I see the translation of the document.
Yes. Can you tell the court if that is the case that you were familiar with before we have shown you this document?
No.
Yes.
And these documents, that's rather towards... sorry.
This prior document was issued by the Supreme Court. In this document, the court states that measures applicable to elderly people are not to be executed by prison administrations, but by the public police, and not by the administration of prisons and correctional facilities. So this is a measure applicable to elderly people, whereby a person would be returned from their location, would be taken from their location to a different location. To my knowledge, President Omar al-Bashir has been the subject of this and is in a place different from his place of birth and different from the capital of the country. The same thing is applied to Abd-Al-Rahman Mohammed Hussein and Bakr Hassan Saleh.
Thank you, Mr. Witness. With that clarification, we will ask the Chamber to admit documents 15 and 16, sorry, DAR D31 5x0 366 and 367 into evidence.
Yeah, well, this time I'll check. Mr. Jeremy, any objection?
I mean, I didn't object in advance to the use of this document. I don't see how it is relevant to your Honour's determination of sentence and your determination of what a reasonable person in the position of the accused could have expected to be punished for in 2003 and 2004. Nevertheless, if the defence want to submit it, then we won't object.
Yeah, and on this occasion, because the victims are actually parties, I think, to this. Any objection, Ms. von Westinghausen?
No, thank you, Madam President. No objection.
Thank you. Yes, all right. Yes, Mr. Lauche, those are admitted.
Thank you, Madam President. Mr. Witness, I try to go very quickly. I have 3 questions for you, very focused, and after that, I will move on. Mr. Witness, first question I have is about the Central Reserve Forces, the CRF. Can you please summarize for the court what is the usual, normal mission of the Central Reserve Forces?
All right, are you objecting?
I'm objecting on basis of relevance.
That's my immediate reaction, Mr. Lauche. What's the relevance of this to any sentence?
Can I answer without being listened to by the witness, Madam President?
I suppose so. Can we cut off the feed or not? No.
The audio to the witness has been cut off.
Right. Yes, Mr. Lauche.
Thank you, Madam President. According to the trial judgment, the attacks on Kodum and Bindisi were perpetrated in the presence of members of the Central Reserve Forces, and I want to clarify with the witness whether it forms part of the usual mission of the Central Reserve Forces to protect the population, because that's relevant for the definition of IRABA.
Sorry.
Microphone, please, Your Honour.
I'm sorry. I'm afraid you really lost me there, Mr. Lauche. The presence of the CRF in the attacks has got to do what with, well, apart from whether it has anything to do with Hiraba, what has that got to do with sentence?
One of the issues that I will have to submit to you is whether the exception to the exclusion of imprisonment for people of more than 70 years applies in this case. And the answer to that question depends on whether one of the counts for which Mr. Abd-Al-Rahman has been found guilty can be seen as an equivalent to IRABA under Sudanese law, because IRABA is the exception. People above 70 years can be sentenced for imprisonment for a maximum period of 7 years. I want to know if that exception is applicable in light of this event in Kodum and Bindisi.
Yeah, Mr. Jeremy.
Yes, thank you, Madam President, Your Honours. So, to be clear, the sentencing hearing is not an opportunity to relitigate issues decided at trial, decided in your judgment. It's not an opportunity for Mr. Lauchi to conduct re-examination of a witness to whom he has already directed questions on Hiraba 2. The jurisprudence on that is very clear. We cite it in our filing 1248, the Ntaganda Bemba decisions, paragraphs 8 and 17. If Mr. Lauchi has factual legal issues to raise in relation to Hiraba, then the appropriate forum to do that will be before the appeals chamber. The chamber has made findings in relation to Hiraba in this case. The chamber has been clear that the purpose of calling D16 at these sentencing submissions is to hear about his legal interpretation of sentencing in Sudanese law. And therefore, if Mr. Lauchi wants to say to the witness, what is the sentence in relation to Hiraba, then that is fine. We wouldn't object to that. But if he is to start to try and reopen the entire concept of Hiraba, when it applies, if the CRF are present in Kodum, in Bindisi, then that is totally inappropriate in the course of this sentencing hearing. in my submission, Your Honour.
Mr. Latry? I may say I agree with Mr. Jeremy. And indeed, there are a number of occasions when you do try to reopen this, as I'm going to deal with at the end of this.
I thought I was not, Madam President, but if you tell me that your trial judgment includes a positive finding that a crime that is equivalent to Iraba was committed, I have no more questions on this topic.
Well, I'm not telling you anything, Mr. Latry. You can read what is in our trial judgment. What I am saying is that Mr. Jeremy is right when he says there is clear authority that you cannot seek to reopen matters which have been the subject of the trial judgment at a sentencing hearing. You can argue this, as he has said, in one of your 79 grounds for the appeals chamber.
Very well, Madam President, but I'm still not clear as to whether the opinion of the chamber is whether something equivalent to Iraba was committed in Kodum and Bindisi.
Well, I'm afraid you will just have to live with that,
Okay.
Mr. Latry. You can ask him in general terms. What you can't do is go into specifics like that.
Let's save time. Thank you, Madam President. We can reopen the...
Back into, yes, reopen the link and then back into public session, please, open session. And we won't open session.
Mr. Witness.
Madam President, the audio to the witness has been reconnected.
Yes, thank you.
Mr. Witness, forget my previous questions. I withdraw it. And I'm left with one question for you. Can we have, please, on the screen, document number 14 in the list of materials? That's DA OTP 0118-0075, which is the English version of the 1986 People's Armed Forces Act. And I would like to go at page 0082. That is Article 4 of this Act. Mr. Witness, in your statement in relation to count 1, the attack on Kodum and Bindisi as a war crime, I asked you what was the applicable sentence under Sudanese law, and you referred to the Act of 1986 in your answer.
What paragraph is that, please, Mr. Latry?
In the statement?
Yeah.
Unfortunately,
I think it's paragraph 20, Your Honours.
thank you. Paragraph 20. So my question is, Mr. Witness, this attack on Kodum and Bindisi was, according to the trial judgment, perpetrated by a group of people called the Janjaweed. Can you please tell us in which category of the Article 4 the Janjaweed are falling, please?
Article 4 has determined. I don't see the article before me, but I have seen it quite enough to memorize it. Article 4 specifies those who fall under the provision of the 1986 Sudanese Armed Forces Act. Article 4 cannot be separated from Article number 5 from the same act. Darfur was declared emergency area. All the police forces and security forces, according to this article, Article 4, work under the command of the armed forces. And any crimes committed there are prosecuted according to the 1986 Armed Forces Act.
Thank you. So, to be clear, is there any category of Article 4 under which the Janjaweed would fall? Or shall we refer only to Article 5?
Objection, relevance, Madam President.
I mean, there's a lot. One could query the relevance of in this whole statement, Mr. Jeremy. So I don't think it really matters if there's one more aspect.
Okay, but just for the record, again, we're going back into issues that this Mr. Lauchi explored with this witness extensively during his direct examination, and I struggle to see how these questions are relevant to sentencing, which is the purpose of these proceedings.
All right, Mr. Lauchi.
Well, the purpose is to understand the purpose is to understand the response from the witness and how the 1986 Act applies in his expert opinion on the Janjaweed.
But didn't he? I thought. I mean, it's a long time since I've read this witness's evidence, but I thought he did deal with that during the trial. It was part of the reason why you called him. I'm pretty certain he did.
I can refer to his former responses to this question, but in the purpose of the sentencing, because he was referring expressly on this provision, I thought it was good to clarify it with him.
Well, Mr. Jeremy, I'm pretty certain, I think you're right, he did deal with this during the trial, because that's one of the reasons why he was called.
Yes, Madam President, I've got the reference here, transcript page 131, pages 20 to 21 in particular. And again, Your Honours, this is going back into issues that have already been explored, and this should not be re-examination by Mr. Lauchi.
No, all right, Mr. Lauchi, unless you've got anything else to say, then I agree. I mean, you are really attempting to go back over issues that were litigated.
Thank you, Madam President. In that case, I have no more question, and I may reserve my other questions for re-examination if necessary. Thank you, Mr. Witness.
Well, I'm afraid you can't do that. You can only re-examine on issues that come out during cross-examination.
Yeah, no, I mean, of course,
Okay,
within that limit.
All right. Okay, thank you. Mr. Jeremy.
Thank you, Madam President. Your Honours, I have no cross-examination. Thank you.
Yes. Ms. Fonstein.
Nothing from us, Madam President. Thank you.
Thank you.
Which obviously makes no re-examination on the defense side.
I don't want to check that either of my colleagues. Any questions? Yeah. Judge Alapini. Oh, no. No? Okay. No, no questions from the judges. So thank you very much for attending. That completes your evidence today. Yes? You want to say something? I'm afraid. Sir, about what?
About our situation in the program, in the protection program.
No, I'm afraid not, sir. Anything you want to raise about that, you can raise with the persons with you. It's got nothing to do with us. So thank you very much.
We have already raised this, but there was no response.
Well, I'm very sorry, sir, but this is not the forum to raise issues such as this. So thank you very much, sir. That completes your evidence, and you can leave the place where you are. Thank you. Can we cut the feed? Mr. Lachie. So yesterday, you were about to begin with your submissions in respect, I think you said, of the victims.
Yes, Madam President, but before that, with your permission, we had requested the possibility of having a final greeting session, so a very short break, to have a greeting session with the witness.
I don't remember seeing that, but all right, you want the break to be taken now?
There is a solution. My colleague Ian Edwards starts, and I go to visit the witness, and I come back when it's done.
All right. That's fine by us. Yes. Thank you.
Good morning. Your Honour, I will shortly address you on the mitigating circumstances present in this case. But before I do, there are three brief points I would like to make regarding the gravity of the crimes for which Mr. Abd-Al-Rahman has been convicted. These supplement some of Mr. Lachie's submissions already made, and perhaps others that he'll make later on today. But the thrust of the submissions is that the crimes for which Mr. Abd-Al-Rahman has been convicted do not meet the level of extreme gravity that justify the imposition of a term of life imprisonment under Article 77(1)(b). Firstly, the prosecution and the LRV have addressed you both in written submissions and orally on the gravity of the offending. It is admittedly a trite point, by which I mean it's not a particularly original or insightful point, but it's worth making anyway. All cases that are heard at this court are grave. It is in the nature of the jurisdiction of this court that all cases that come before it are the most serious crimes of concern to the international community. The gravity bar is already very high. So to give Article 77(1)(b) any sense, extreme gravity cannot mean the same thing here that it would in a domestic court. Extreme gravity, we submit, within the meaning of Article 77(1)(b, must be understood to mean extreme within the context of the grave crimes that are routinely considered at this court. Secondly, I'd like to address you on the temporal scope or duration of the offending as found. Passing reference is made to this in paragraphs 167 and 168 of the prosecution's submissions, and Mr. Nichols yesterday spoke of crimes committed over a lengthy period of time at page 3 of yesterday's transcript, the uncorrected transcript. For their part, the LRV at paragraph 55 of their submissions argue that the 4 incidents form a single course of conduct. And as a matter of law, we agree. But in terms of the temporal scope, as a matter of fact, we submit that it is clear that the period of time in which crimes for which Mr. Abd-Al-Rahman falls to be sentenced those crimes were committed in a relatively limited period of time. So, as far as the Kudum and Bindisi attacks are concerned, they took place over 2 days, the 15th and 16th of August, 2003. Even if you were to conclude that you cannot reasonably ignore the operations that preceded Kudum and Bindisi, operations against the 9 villages to the north and east of Mukjar. These started, as you found, on the 9th of August, 2003. 2003. Whilst it's right to say that Mr. Abd-Al-Rahman was not charged with any crimes relating to these preceding operations and can't be sentenced for any crimes, nevertheless, factoring in those preceding attacks, we're talking about a period of about a week. The Chamber then heard evidence of the Sindhu and Mukjar operations, which occurred in February 2004, some 5 months later. Mr. Abd-Al-Rahman is not charged with any crimes for which he falls to be sentenced over that 5-month intervening period. The crimes relating to Mukjar occurred in late February or early March 2004. And the crimes for which he stands to be sentenced at Mukjar police station and then the executions outside of Mukjar occur over a period of days. We're not talking about weeks, we're certainly not talking about months. The crimes in and around Delej, for which Mr. Abd-Al-Rahman has been convicted, 5th and 7th of March, immediately following on from Mukjar. We say that it cannot sensibly be concluded that there is no overlap between those 2 operations, Delej and Mukjar. But again, Mukjar and Delej, we're talking about a week, maybe days, not months. The prosecution's brief submissions on the question of temporal scope being a factor that demand a finding of extreme gravity so as to justify a term of life imprisonment do not survive contact with any reasonable analysis of the facts, Your Honour. We also say that Mr. Abd-Al-Rahman's case can be distinguished from that of other cases that come before the ICC, where the temporal scope of offending was truly significant, was truly large, and was truly grave. Lubanga was convicted for offences that spanned the whole period between September 2002 and August 2003. Taganda was convicted for offences spanning the whole period of August 2002 to December 2003. Ongwen was convicted of crimes over the 3-year period of 1st of July 2002 to the end of December 2005, 3.5-year period. So the shorter and more limited periods of Mr. Abd-Al-Rahman's criminality, as found by Your Honour's Chamber, is a relevant and significant factor that ought to be taken into account in bringing the gravity of these crimes down from the level of extremity urged by the prosecution and that might otherwise warrant a sentence of life imprisonment. My third and final point on gravity before moving on to mitigation relate to specifically the rape counts for which Mr. Abd-Al-Rahman is to be sentenced. I make it absolutely clear from the start that the defence does not and has never disputed that rapes and other acts of sexual violence occurred in the Mukjar and Wadi Saleh localities in 2003 and 2004. We made that clear during the trial. I reiterate that we make that clear now. Nothing I say is intended to diminish the seriousness of the rapes and sexual violence suffered by all the victim survivors, some of whom testified with such courage at this trial. We don't dispute their terrible suffering at the time and the suffering that they continues today from the consequences of that violence. Whilst Mr. Abd-Al-Rahman has been convicted of rape as both a crime against humanity and a war crime, it was never part of the prosecution's case that he ever committed rape or any offence of sexual violence as a direct perpetrator. It has never been suggested that any victims of rape were forced into sexual slavery. His case, Mr. Abd-Al-Rahman's case, can be contrasted, we say, with, for example, Mr. Ongwen, who was convicted of rape, of forced marriage, of sexual slavery, as a direct perpetrator over periods extending over many years, where women and girls were raped systematically, day after day, week after week, month after month. He doesn't fall into that category. Mr. Taganda was found to have been aware of women and girls being brought to his camp, and even brought women to his camp himself, knowing what was likely to happen to them. So we submit that that contrast between Mr. Abd-Al-Rahman's case and those of others brings the sentence for the rape of no fewer than 16 women and girls down from the near maximum sentence of 27 years recommended by the prosecution. And this should also be taken into account in the contribution that the rape convictions make to the level of extremity of the totality of Mr. Abd-Al-Rahman's criminality as found, that the prosecution misguidedly argues warrant a sentence of life imprisonment. That's all I have to say about gravity. Turning then to mitigating features that exist in this case, and really the submissions on mitigating circumstances have been set out fairly fully in our brief. I'm certainly not going to waste the court's time by repeating them. I'm going to limit myself to addressing the points made by the prosecution from paragraph 145 onwards in their sentencing submissions and from the submissions made by my learned friend for the victims. let me deal first with a topic that has created some rather heated debate, and it's the matter of voluntary surrender. It is the first point, point A, at page 43 of the prosecution submissions. Yep. And we deal with the question of voluntary submissions in our paragraphs 81 to 86 at point F. And as I say, we rely on those submissions. Cooperation is provided for in the texts by Rule 145.2a Roman 2 in the rules as a mitigating factor. The most decisive way an indicted person can cooperate with the court is through voluntary surrender, we say. It'll be noted that Rule 145, if you have it before you now, well, perhaps you can take it on trust.
I will take it on trust, but I was just thinking that we didn't appear to have a copy of either the statute or the rules here in court.
Can I hand up my
I think we're going to be given... Even better if we've got 3 copies. Thank you very much. Yes.
Yes, 145.2a2. Well, I'll read it. The mitigating circumstances such as, so it's not an exclusive list, the convicted person's conduct after the act, including any efforts by the person to compensate the victims, and, here I stress, any cooperation with the court. Now, Rule 145.2a Roman 2 contains no limiting sub-rule. It doesn't say that cooperation has to be of a certain nature or done within a certain deadline. It's open-ended. The words in the text are any cooperation with the court. Full stop. The prosecution takes a rather maximalist, rather breathless position that shows no evidence of having been passed through any filter of moderation. The prosecution asked the trial chamber to find to find extremity, leaving no room for mitigation. But here there is real mitigation. It's mitigation that permits the chamber to take a step back from the exceptional line of life imprisonment, so that that sentence can be reserved for the very worst of the worst.
Sorry, Mr. Edwards. I think they're just saying, well, the prosecution and indeed the representative of the victim are both saying you don't get any credit for it. And I think that's what you need to deal with.
Yeah.
Because you, as you said when you arrived here, Abd-Al-Rahman said when he, Abd-Al-Rahman said when he arrived here, he surrendered because he was wanted in Sudan and feared for his life.
Well, that's right. That's what they say.
No, that's what he says.
Well, the prosecution make that argument. I was going to come to it in a moment, but I'll deal with it now. In other words, they're saying that he had a selfish reason for surrendering himself to the court. For the prosecution, from a learned friend, his motives for surrender aren't pure enough, and that should erase all mitigation afforded to him. The prosecution cites to no, nor do the LRV, cite to no judicial authority for the proposition that below a certain level of virtuousness connected to surrender, no mitigation should attach. Not only is this an argument, we say, devoid of any merit, it would require an application of the most subjective assessment of righteousness that this chamber, we say, should not engage in. But moving on from that, it's more accurate to describe Mr. Abd-Al-Rahman's motives as mixed rather than entirely selfish. Even if there was an element of his having a preference for not being arrested in Sudan and facing the prospect of detention in a Sudanese jail, followed by a trial in autocratic Sudan, followed by possibly the death sentence. Who could blame him for having that preference? But that's not the end of the matter. In his unsworn statement of the 13th of December 2024, this is transcript 162, he explains that there were other motives, so that the court would look into my case and tell me what my fate is. And the prosecution even cite that at their footnote 391. He's prepared to submit himself to the authority of the court to defend himself and to learn of his fate. So to say that his impure motive is the entire truth of the matter is simply not accurate. The black and white picture painted by my learned friends is rather more nuanced, rather more complex. Moving on from that, we would say that, so what if his motives were less than purely selfless, if they were less than 100% noble? The fact of the matter is, he did surrender. And the direct result of that
Sorry, Mr. Edwards.
No, I can pause if...
No, I'm actually looking for... I printed out the... Mr. Rahman's remarks, both at the beginning and the end, and I left them in court last night, but they seem to have gone AWOL somewhere on this. Does anybody know what happened to my... All right, you carry on, Mr. Edwards.
Yes.
I'll find it in the break.
The point I was making is, so what? The fact is, he did surrender, and the direct result of that decision is that the court has conducted its only trial arising out of the tragic events in Darfur in 2003 and 2004. The direct result is that victims have been able to come to this court and tell their stories. And, Your Honours, we make this point because we think it's fair. For the most part, in terms of crime-based witnesses, the defence did not challenge the essence of their evidence, did not challenge the traumatic events that they suffered. For the most part, the defence accepted the truth of the crime-based witnesses. of their accounts of the crimes that they endured, their suffering, and their suffering to this day. And indeed, there were occasions when, in Your Honour's closing words to witnesses, you said to crime-based witnesses that the defence had not taken issue with their accounts. We did, throughout the trial, minimise, as best as we could, any re-traumatisation of prosecution and LRV witnesses, whilst advancing as robustly as we could our case based on decoupling the alleged links, alleged as they were, between our client and the crimes. Your Honours have seen for yourselves how courageous and dignified the crime-based witnesses were when they testified. And you may think that for many it amounted to a cathartic experience. They told their stories to a room full of strangers in a faraway land who were happy and prepared to listen to them and believe them. And you may think that that played some small contribution to their healing. None of that would have been possible had Mr. Abd-Al-Rahman not surrendered himself. And we say, for that, he deserves some credit. Now, the prosecution and the victims rely on what the trial chamber says in Taganda. In our submission, following that reasoning would be to take the wrong path and would continue to send out the wrong signal that was originally sent out in Taganda. You're not bound by the trial chamber's decision in Taganda. It wasn't a point taken on appeal, so we don't have appeal chamber authoritative words of wisdom on the question. The prosecution, I think, also relied on Merksic and Pandurovic from the ICTY at their paragraph 148. You're not bound by that. There is no doubt, I think it's agreed, that voluntary surrender brings considerable benefits to international courts. There are nearly 30 persons who have been indicted by the court and who remain at large, including Messrs. al-Bashir, Haroun, Hussein, Banda, all from Sudan, Saif Gaddafi in Libya, Kony. There may be many more who are the subject of warrants of arrest that are currently under seal. The court has no police force. The court relies on the cooperation of national authorities to effect arrests and the transfer of indictees to the custody of the court. The history of that cooperation can properly be described as uneven. Just this year, a state party, Italy, arrested a suspect pursuant to an arrest warrant and refused to hand him over. Hungary, a state party, has refused to execute an ICC arrest warrant against another indictee. And that has led to Hungary notifying its withdrawal from the Rome Statute. This court cannot rely on the cooperation exclusively on states' parties, on the cooperation and goodwill of parties to bring suspects to the court. It cannot be enough if the court has an interest in fully exercising its mandate. As a matter of realpolitik, the court has to rely on indictees surrendering themselves, and nothing should be done to dissuade indictees to do so. Everything, on the other hand, should be done to signal that those who will hand themselves in can expect that that act, whether selfish or selfless, will be taken into account as mitigation. Your chamber has an opportunity today, an important opportunity to give that signal and to break from the, I'll describe it as the unfortunate finding in Taganda, that a delay will reduce its value as a mitigating factor. Voluntary submission should be encouraged at any time and should be rewarded.
As I said, Mr. Edwards, I think the argument is not so much that he didn't surrender himself, but that the reason for the surrender is exigent circumstances in his home, where he was, as it was with Taganda, so is the argument. So, just so that we're clear, you argue that even if it is not, as you put it, motives are mixed and not entirely a voluntary one, for the purposes of encouraging people to surrender on the basis that there will be some kind of a reduction, there should be a reduction.
Yes.
And that the extent of the reduction, you argue, would be the reason, the extent, the length of time, the reasoning behind it, all of that would be factors the court could take into account.
Yes, I don't suggest that they couldn't be taken into account. But I think that the crux of our position is that the eventual presence of an indictee at this court, even if delayed, will always be infinitely preferable to no presence at all.
Yeah.
So even if delayed, and even if the motives are mixed, the fact of voluntary surrender should be taken into account. And as a matter of principle, it's wrong that it isn't. So we ask you, tear up the Taganda authority, the jurisprudence from Taganda. It's wrong in principle and it's dangerous. I have another point to make, and it's moving from the general, from the argument of principle to the specific in this case. Your Honour will recall that there was much litigation in the early stages of this case about the criminalisation or not of cooperation with the court under Sudanese criminal law.
Well, it's still continuing, Mr. Edwards, as I see from the appeal.
Indeed. But on the basis of Your Honour's findings, because that's all I need to refer myself to. In your decision 561 of 21st of January 2022, you found that there was not, at that date, any surviving criminalisation of cooperation with the ICC in Sudanese law. And that finding was based on a report of the matter produced by the registry. The Sudanese statute, the Miscellaneous Amendments Act, promulgated on the 22nd of April 2020, amended Article 3 of the Criminal Procedure Act of 1991. And paragraph 3 of Article 3 had prohibited any government entity or any person from providing any assistance or support to anyone, and here I quote, in transferring a Sudanese national to courts abroad on account of being accused of committing a crime that constitutes a violation of international humanitarian law, including crimes against humanity, genocide, and war crimes. And that filing is Annex 1 to filing 496 of the 22nd of October 2021. The unambiguous, the absolute prohibition contained in the article which was amended in 2022 suggests that an accused person, him or herself, would be in violation, April 2020, not 22, suggests that an accused person, him or herself, would be in violation of Sudanese criminal law for attempting to surrender himself to a court outside of Sudan. And it's through that prism of domestic incrimination, penalization, that Mr. Abd-Al-Rahman's failure to take the first steps to surrender himself to the court can be seen. It mitigates significantly, we say, the delay. Had he surrendered himself earlier, he would fall afoul of Sudanese criminal law.
Well, you've lost me there completely, I'm afraid.
Right.
He surrendered himself in June 20.
Yes.
The law, you said, has come in April 20, is that right? Where is it?
April 2020, yes.
April 2020.
Yes. He surrendered himself
in June?
In June, yes.
So before then, he wouldn't have been afoul of Sudanese criminal law?
No, after April 2020.
Yes. After April 20, you would say after April 20, it became a crime again or it became a crime?
No, it's exactly the opposite, Your Honour. Up until April 2020, it was a crime to cooperate with the ICC.
I did think this was part of the argument in the during the course of the trial.
Yes.
And I can't remember the reason why we found it, but we found that it wasn't a criminal offence.
No. The situation was this. Your Honours found that the miscellaneous... Your Honours found at the time of our argument that cooperation with the ICC was not criminalised in Sudan. You made that finding on the basis of a registry's report containing, which referred to correspondence with the government of Sudan, who pointed the registry to an amendment in the criminal law of Sudan contained in the Miscellaneous Amendments Act, which was promulgated on the 22nd of April 2020. Prior to that promulgation, cooperation with the ICC had been criminalised. After April 2020, it was no longer criminalised. The debate between the defence and the prosecution, and ultimately found for the prosecution, was that we said the Miscellaneous Amendments Act was not clear enough to demonstrate that continuing de facto criminalisation of cooperation with the ICC continued even beyond April 2020. But before April 2020, I think it's right to say that there was never any dispute that it was criminalised.
I don't want to object. There certainly was a dispute.
Yeah. I remember, as I say, I remember the dispute. I don't remember the details. But in any event, Mr. Edwards, I'm not at all clear what that has got to do with your client's decision to surrender himself, because he said himself it had nothing to do with the criminal, whether or not it was criminalised. It was all to do with whether or not he was being sought for the purposes of arrest for the short period of time that Sudan had a democratic government of sorts.
Correct, and that well, correct. Those were the submissions that we made on instruction, and that.
There, go on, Mr. Edwards.
And that was what Mr. Abd-Al-Rahman said in unsworn statements. All we're saying is that it is our submission that on top of everything else, for many of those 13 years between the issuing of the arrest warrant and his surrender, we say that criminalisation of cooperation in the ICC was a factor. It was it was a reality. It was a reality in Sudan. And I simply refer you to Annex 1 of filing 496 of the 22nd of October 2021, in which the registry makes the position reasonably clear.
All right, Mr. Nichols.
I really apologize for rising and objecting during these submissions, but we've gotten to the point now where my friend is testifying. They made their argument before. Mr. Lauchi said in the opening, I'll tell you the reason he surrendered. It was because he thought he was going to get arrested and it would have been much worse in Sudan. Now he had in his head it would be criminalized, he was committing a crime. I mean, he cannot testify about his client's motive when the client has not testified at all. I'm not on my feet sure what unsworn statements he's referring to, but he cannot give evidence that this is a reason that at this point, apparently the client has a deep understanding of Sudanese criminal law, and that was in his mind and that was part of his motivation. And if it wasn't, it's totally irrelevant.
Yep, all right. Mr. Edwards, that must be right. Your client didn't give evidence, as it was his right. He made some unsworn statements which were entitled, and you are entitled to look at, but you cannot give evidence about matters that he didn't give evidence about, or indeed didn't say anything about.
And Your Honour, if it came across that I was giving evidence, if it was coming across that I was telling the court what was in Mr. Abd-Al-Rahman's mind, in the absence of him having even given an unsworn statement, that was never my intent. I'm simply saying that as a matter of Sudanese law, cooperation at the time was criminalized. That is all. Nothing more and nothing less.
A suitable point to take the break?
Yes.
Or do you want to say anything else about this aspect?
No, if Your Honour just gives me a moment, I jumped back and forth in my submissions to deal with a matter that Your Honour raised early on, but I think I have covered everything that I wanted to say about surrender. Would you just... No, that is a good natural break.
All right. Can I say, sir, as I said to Mr. Larch yesterday, I interrupted, but I think because I suppose you and I, Mr. Edwards, are both used to judges interrupting counsel. But if you'd prefer, there are a number of matters, particularly that have been raised by the prosecution and by the representative victims, which I feel, in fairness to you, and so we can understand the position you need to deal with. But I can leave them until the end, or I can deal with them as and when they arise, the topics. As I said to Mr. Lauchi yesterday, whichever you prefer.
My preference, I won't speak for Mr. Lauchi, my preference in the course of my submissions, and I'm about a third of the way through what I wanted to say, is if Your Honour's happy to ask them at the time, that way it's all fresh in our minds, and I'll deal with them as we come across them.
Well, that's very helpful. Thank you, Mr. Edwards. Yeah. And I see Mr. Lauch nodding. Yes, we'll take the break now till 11:30.
All right, we will be.